Now to the latest on the timing of the Georgia election interference case. Two of the 19 defendants attempting to sever their cases from the rest of the group. Former Trump lawyer Sidney Powell is asking a judge to completely separate her trial. Lawyers for Powell wrote in a court filing, the case is so weak, a trial judge would dismiss the charges before it even reaches a jury. Their opinion. The motion reads in part, quote, contrary to widely publicized false statements in the media, Sidney Powell did not represent President Trump or the Trump campaign. She had no engagement agreement with either. Powell's team is asking for an evidentiary hearing on the filing. Meanwhile, Kenneth Chesebro also filed a motion yesterday to sever his case. Chesebro was already granted a request for a speedy trial. His first court date scheduled for October 23rd. District Attorney Fani Willis asked the court this week to move the trial of all defendants to that date. Joining us now, former District Attorney for DeKalb County, Georgia, Gwen Keys Fleming. Ms. Fleming, thanks for your time this morning. We appreciate it. So if you could help us sort through how this all works when you have 19 co-defendants, a couple of them wanting separate trials, DA Willis saying, well, let's just do them all at the same time. Obviously, that's highly unlikely to push all of those into October too soon. How does this all shake out?
Well, I think what you're seeing is what we estimated, that there would be several defendants that would look at their cases, talk with their lawyers, and come up with different strategies, one of which is to file a speedy trial demand, which we've seen now from several defendants. The other is to start to sever their cases from the other defendants. And so generally, defendants try to do that when there is a risk of the evidence against a co-defendant tainting the first defendant's case or defense or strategy at trial. And all of this is left to the judge's discretion, which is why I believe an evidentiary hearing would be appropriate. The problem is that all of these defendants are charged in one count of RICO, and so it is about the connectivity between all of their actions.
And let me ask you this, as you look at a slate of 19 co-defendants, is there a chance at this point in the process that one or several of them could come forward to the DA and say, let me help you out here with Donald Trump, let me help you out here with Rudy Giuliani? In other words, could turn and help the prosecution?
I think that's always possible. And again, we may start to see that once the defendants get a chance to look at the DA's discovery. I know she has indicated that there are terabytes of information available for them to be able to review. And perhaps after that review, we might start to see some of those decisions being made.
So, Gwen, the DA has outlined a pretty aggressive timetable here to bring potentially all of these trials to court. What is, though, in your estimation, sort of a realistic time frame as to there are so many defendants, there's possibility, as Willie just said, maybe even some could flip. It's such a sprawling case. What feels like a right timeline to you?
Well, certainly at least one case, possibly more, will start on October 23rd. I think it's going to take a little while to strike a jury to make sure you have folks that have an open mind and will be able to judge the evidence fairly. I think after that, for possibly one defendant, it might take 4 weeks or so. But again, the DA is ready on all 19. Many people questioned why she took so long with the investigation. I surmise that it's because she anticipated getting a speedy trial demand and knew that she would have to be ready in a short amount of time.
Ms. Fleming, Sidney Powell, her lawyer, has filed with the court the following part of the following motion. Quote, assuming the prosecution does not realize its error in indicting her and agree to dismiss this wrongful prosecution before trial immediately, if she does go to trial, she should receive, quote, a judgment of acquittal when the state rests. Given Ms. Powell's public pronouncements for months on end about this case prior to her being charged, what do you think the reaction of the judge would be when he reads this motion fully?
Well, again, I'm not surprised of the motion, and what it's asking for is a directed verdict after the DA puts on its case. The challenge is the DA has yet to put on her whole case, and so the judge is going to let the DA do what she's going to do in terms of calling her witnesses, presenting her case, and then the judge can make a decision as to whether there's sufficient evidence to move forward and have the case go to the jury or have the defendants put on their own evidence.
So staying in the state of Georgia, a federal judge ruled yesterday Rudy Giuliani defamed 2 election workers in Georgia following the 2020 election. The ruling means he is liable now for damages, which will be determined at a civil trial. Former poll workers Ruby Freeman and Shay Moss sued Giuliani over his baseless claims they committed election fraud. Both testified to the January 6th committee. Their lives were turned upside down by those allegations.
Now I won't even introduce myself by my name anymore. I get nervous when I bump into someone I know in the grocery store who says my name. I'm worried about who's listening. I get nervous when I have to give my name for food orders. I'm always concerned of who's around me. I've lost my name and I've lost my reputation. I've lost my sense of security.
A lot of threats, wishing death upon me, telling me that, I'll be in jail with my mother, and saying things like, be glad it's 2020 and not 1920.
Were a lot of these threats and vile comments racist in nature?
A lot of them were racist. A lot of them were just hateful.
And all of that sparked by false comments made by Rudy Giuliani. He conceded, in fact, in a court filing last month, he had made false statements about Freeman and Moss, also failed to produce any evidence during the discovery portion of his case, leading to the judge's defamation ruling. In a statement, Freeman and Moss said the ruling brings them one step closer to rebuilding their lives. A spokesperson for Giuliani said he's been wrongly accused. So, Gwen, Moss and Freeman had their lives effectively ruined by Rudy Giuliani casually saying that they were passing a USB stick, or perhaps he said like they were vials of cocaine among them, suggesting there were votes on the USB stick. There were not, as we heard. It was a mint. But just speaking legally here now, this is a civil case. Obviously, Giuliani isn't going to go to jail over any of this. But what happens from here now that the judge made that strong ruling yesterday in which she said also, Rudy Giuliani, you are not the victim in this case, as you're trying to portray yourself. It is Ms. Freeman and Ms. Moss who are the victims here.
Well, the interesting thing is justice comes in many forms, right? That's why we have both criminal and civil aspects of the law. And so now the civil case will be able to move to a stage where if it can be quantified, that there will be some sort of reimbursement for the pain and suffering that both Ms. Moss and Ms. Freeman suffered. And so, again, this is part of how our justice system works. These are all viable avenues for folks who feel as though they've been wronged in one way or another.
And another message that there are consequences when you casually throw out these outrageous allegations. Former DeKalb County District Attorney Gwen Keyes Fleming, great to have you with us this morning. Thanks for being here.
Thank you.